On 25th October 2019, both the phones of the accused and the victim Syombua were active from the morning hours to around 18-16 hours before the victim's phone went dead while at the barracks premises near that of the accused. Chief Inspector Joseph Kolum, PW 26, is a cybercrime expert attached at the DCIA headquarters. He was requested by PW 22 via exhibit memos dated 30th November 2019, exhibits number 33A to E, to recover messages from the mobile phones of the accused, the mobile phones of the victims, and that of PW4. From the dead victim's phone, that is Exhibit 6, he was to extract messages and produce the extraction report, Exhibit number 42A, B, and C. He recovered messages from phones belonging to PW2, PW4, and that of PW1. They were produced as exhibit number 34, 39, 41. The extraction reports were produced as exhibit number 35, A and B, and the certificates as exhibit number 38A and B, 40A and B. However, the witness was not able to recover messages from the accused's mobile phone, exhibit number 9, as they had been deleted. The recovered data was from the SIM cards and not from the phones themselves. The investigating officer, upon going through the statements of the witnesses and the exhibits, came to the conclusion that it is the accused who committed the murder of the 3 victims and was helped to dispose of the bodies with the help of PW1 Collins Pamba. That some of the exhibits, namely a djembe, spade, and black shoes, which were recovered from the house of PW1 upon forensic examination, had soil which was similar to that found at the shallow grave which placed PW1 at the scene. He also gathered evidence to the effect that the accused left the camp on 26 October with his wife and had lunch at Kirimara Springs at Nanyuki town and returned to the base with her, but never left the base alive. DNA examination by the experts showed that the 2 children belonged to the deceased and the accused. Now, the law analysis and determination. Section 203 of the Penal Code provides, and I quote, "Any person who of malice aforethought causes death of another person by unlawful act or omission is guilty of murder." Section 206 of the Penal Code also provides as follows, and I quote, "Malice aforethought shall be deemed to be established by evidence proving any one or more of the following circumstances. A, an intention to cause the death of or to do grievous harm to any person, whether that person is the person actually killed or not. B, knowledge that the act or omission causing death will probably cause the death of or grievous harm to some person, whether that person is the person actually killed or not. Although such knowledge is accompanied by indifference, whether death or grievous harm is caused or not, or by a wish that it may not be caused. C. An intent to commit a felony. D. An intention by the act or omission to facilitate the flight or escape from custody of any person who has committed or attempted to commit a felony. In the case of Attorney Degwa Ngari versus the Republic 2014 EKLR, the Court of Appeal identified 3 ingredients to be proved in a case of murder. A. That death of the deceased. B. That the accused committed the unlawful act which caused the death of the deceased. And C. That the accused had malice aforethought. Now, as regards death of the deceased persons, though the accused denies having married Joyce Syombua Maua, there is DNA evidence to the effect that they were in a relationship which produced 2 children, namely Shanice and Prince. The first DNA test was conducted upon orders by the Milimani Children's Court. The accused, after contesting paternity, was found to be the father of the 2 children. In the course of investigations, a government chemist, Joyce Syombua, conducted a further DNA examination of the victims' bodies and ascertained that the bodies belonged to Joyce Syombua and her 2 children, Shanice and Prince. The 3 bodies were exhumed from a shallow grave at Thingithu area of Nanyuki. An autopsy was conducted by the chief pathologist, Dr. Johnson Oduor, PW22. And the cause of death of Joyce Syombua was a result of blunt force trauma, whereas her 2 children was strangulated. The 3 deceased persons did not die from natural causes. Now, whether the accused committed an unlawful act which caused the death of the deceased persons. Collins Pamba, PW1, was the prosecution star witness. He did testify at length of how the accused called him while at the airbase and told him to go to his house. Instead, they proceeded to room A4. He opened the room by the use of a key, proceeded to the bathroom, and the witness observed a body lying on the ground in a transparent gunny bag. There was another body at the bathtub with a shaven head. The other one had a plated head. Both were small children. He was instructed to help the accused take the bodies into the boot of the accused person's car, registration number KCP 740F, parked outside. Thereafter, they proceeded to the accused room A3, where he observed another body. This one was of a lady dressed in white trousers. They used 2 gunny bags to cover the head and the legs. They placed the 3rd body on the top of the 2 others. They used ropes to tie the gunny bags. They left the base uninspected and proceeded to a dump site where there was a shallow grave and dumped the bodies there and covered them with soil. At this stage, it is incumbent upon the court to warn itself that PW1 was an accomplice after the fact, and further, that he did plea bargaining, as a result of which he was charged with a lesser offense, and upon conviction was sentenced to 5 years imprisonment. The plea bargaining could have been anchored on him testifying against the accused. It is therefore necessary to establish whether there is sufficient evidence to corroborate that of Collins Pamba. The court bears in mind the motive provided by the prosecution. The Milimani Children's Court case, Joyce Syombua versus Peter Mwaura, where the children court granted Joyce Syombua maintenance of 25,000 shillings monthly. The accused made only one payment, and barely 3 months after the judgment was delivered, the accused managed to convince Joyce Syombua to visit him at Nanyuki Airbase together with their children. She did visit him on the 25th day of October 2019 together with their children. The accused does not deny or dispute this fact. From the evidence adduced by Farizana, PW4, a friend of Joyce, they were in communication throughout the period of 25th October and the larger part of 26th October. When at about 6:39 p.m., Joyce's phone went dead. It is instructive to note that PW1 did testify that the accused called him that evening to help him dispose the bodies. The accused himself does not dispute the fact that on 26 October 2019, he left with Joyce Syombua and proceeded to Kirimara Hotel, where they had lunch, returning at around 6 p.m. When the accused was asked the whereabouts of the children, he said that he had handed them over to a friend of Joyce, but he did not know her name. He could not have handed them over to somebody else when the bodies were found in an adjacent room to his. Whereas the witnesses manning the airbase gates saw the accused in the company of his wife and children enter the base, they did not see the deceased persons leave the facility. Now, as to whether the accused had malice aforethought, Section 206 of the Penal Code defines aforethought as an intention to cause a death or to do grievous harm to any person, whether that person is the person actually killed or not. It is an evidence that the relationship between the accused and Joyce Syombua was in the doldrums. The accused was of the view that she had befriended other men, and that's why he had asked for a paternity test. Thereafter, he lured the deceased to his place of work at Nanyuki and enlisted the help of PW1 in disposing of the bodies. The two children died of strangulation, and their mother sustained a blunt force trauma to the head. The force used to kill the three was brutal and was intended to kill or to maim. I have gone through the evidence by the defense and their submissions. It is noted that the gist of the defense is that the accused was framed for the offense of the three murders. It also questions the process of the arrest and subsequent arraignment in a civil court. It is the contention by the defense that nobody saw the accused kill the three deceased persons, and therefore The evidence before the court is purely circumstantial in nature. The defense places reliance on the case of Joan Chebi Sawe versus Republic 203 EKLR, the case of Simon Musoke versus Republic 1958 EA 715, Uganda, Republic versus Suleiman Ali 2021 EKLR, Kerim Arab Koske, and another 1949, on circumstantial evidence which must be proved. And A, if it is firmly and cogently established, and whether it points irresistibly to the guilt of the accused and no one else, and whether it forms a complete and unbroken chain. The defense points out that the gaps in the prosecution case. A, the impossibility of smuggling 3 dead bodies from a highly secured military establishment. B, illegal and unlawful arrest. C, no known place or time of death. D, recovery of deceased lady's phone, devoid of explanation. E, no proof of marriage or cohabitation. F, no proof of alleged non-compliance with children court orders. And G, multiple alternative possible perpetrators with motive, means, and opportunity. On the gaps alluded to by the defense, the first one, impossibility of smuggling 3 dead bodies from the airbase. It is not in dispute that the accused was the duty officer at the time at the airbase. The men manning the gates were his juniors. They did testify in court that they were punished by the authorities for their negligence on the day in question. And B, as to the issue of illegal arrest, a report was made at Kayole by the mother of the deceased that that her daughter was missing after visiting the accused at Nanyuki Airbase. The accused was handed over to civil police by the military police. C, on the issue of no known place and time of death, the bodies were seen by PW1 at room A4 and A3. A3 was the room occupied by accused. A4 was occupied by another officer who was not present at the time. And D, recovery of the deceased phone. This phone was recovered in a matatu at Nanyuki stage. It is not clear, however, who and how it was taken there. And E, no proof of marriage or cohabitation. Now, the children court at Milimani deliberated on the issue of paternity. And accused was found to be the father of the children. F, no proof of alleged non-compliance with the children's court decree. The answer to that is that the mother of the deceased, PW2, and Farizana, PW4, testified in court that only one payment towards maintenance was made. G, multiple alternative possible other perpetrators of the unlawful act. It is the accused who lured the three deceased persons to his place of work. They spent the night in his house. Food was served to them by witnesses. The following day, he was seen in the company of Joyce at Kirimara Springs Hotel. Her body was later seen by PW1 when loading it into the boot of the car belonging to the accused. The spare tire had been removed to create space for the bodies. So in this case, there is both direct and circumstantial evidence. And I find no good reason to fault the evidence of the prosecution witnesses. The evidence of the prosecution, I find, irresistibly points to the guilt of the accused. He alleges that he had escorted Joyce and her children to the bus stage, but nobody seems to have seen him do that. Whereas it is upon the prosecution to prove its case beyond reasonable doubt. Section 107(1) of the Evidence Act provides, and I quote, "Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which one asserts must prove those facts exist. It is not enough for the accused to allege that he escorted the three accused persons out of the base and took them to a bus stage for their onward journey to Nairobi. He had facilitated their journey to Nanyuki by sending them bus fare. When they arrived at the base, they were seen by the officers manning the gates. Nobody at the gates appears to have seen them leave the airbase. The accused had custody and control of his wife and children while at the airbase. He was the only person duty-bound to facilitate their exit therefrom. Instead, evidence shows that he murdered them, stuffed their bodies in gunny bags, and hid them in the boot of his car, buried them at an area called Thingitho. He had visited the area before in the company of PW3. This visit was on the 23rd of October 2019, using PW3's vehicle KBX 196G. This visit was registered in the sewerage company's register, which was produced as Exhibit 48B. This goes to show that the accused had hatched the plan or plot to murder the deceased persons before the acts by ensuring that he had a hidden and secure place to bury them, even before he had killed them. The evidence of Peter Mwaura corroborates that of Collins Pamba, PW1, in all material particulars. He had been approached by the accused to help him in killing Joyce Syombua, but he declined and suggested somebody else. Senior Sergeant Ocheng Odoyo, PW16, did testify that Peter Mwaura, PW3, who was the taxman, did access the officers' mess on 26 October 2019 at around midday to visit the accused in room A3. This is the same witness the accused is said to have approached to kill the deceased. The defense finds fault with the evidence of this witness, as his evidence was not verified by call data records. While that verification may be necessary, it is not mandatory, as verification can be made through other avenues and/or records. The upshot of it all is that the evidence adduced by the prosecution. After going through, I'm satisfied that the prosecution has proved its case beyond reasonable doubt in all the 3 counts of murder contrary to Section 203, as read with Section 204 of the Penal Code, and I convict the accused accordingly on the 3 counts of murder.